Okay.
Oh, the window still says click launching, and I'm like, okay, well, any minute it will launch. So great. Hey,
Hi.
good morning.
Yeah.
You've got the better camera angle.
Well, I don't know about that. I'll turn mine off after we get you all ready to go.
So I hear you. I see that my screen, there we go, looks like it's frozen, but I definitely hear you.
Oh.
So am I frozen looking to you?
You're fine.
Okay, so let me, that's weird. My screen is frozen from my vantage point and I see it thinking. So let me let it think.
Yeah. Hey, hear us?
I can hear somebody, whoever said that, I do hear that.
That's Holly. Is that you in Lubbock? She must not have her speaker. Oh, there she is. Okay. All right, so that works. All right, I'm gonna go ahead and mute you then. Yes. So we've got Lubbock, Arlington, a couple of offices. Who else is coming in today? Denton, Greater Denton, Wise County, and 2 private offices.
Okay, so everything's moving on my end. Okay. Can I do a test on the share just to make sure you can see it?
Go ahead.
All right, so let me. All right, so do you see it?
Yep, perfect.
Awesome. And if right now the view that you see, do you see all of my preview panes down one side of the screen?
Yes, I do.
Okay, and I didn't want you to kind of see that. So now you just see the actual running.
Perfect, yeah, that's the presentation view.
Gotcha. And to minimize all of the screens on the sides of my screen that are blocking my content.
There should, at the top of the row of those.
Got it.
There are
yes, ma'am.
doos, and you should be able to drag them wherever you want as well.
Got it. So, okay, and now I see just you and not everyone else that's participating. Okay, I'm just learning what those views look like now that everyone's there. Okay.
Yeah.
I got it. So we're going to hit stop share.
Just reminded me to start the recording. Thank you so much, David. Welcome to our webinar. Today we are presenting how not to accidentally practice law using TAR commercial forms. We'll do a couple of administrative items first. This webinar is about an hour long. We have approved it for CE credit. CE credit, you must be present at a local board or other office with monitoring. So you have a proctor who can sign you in and out and fill out your stuff. You can see people in the little boxes along the side of your screen. Those are all folks who set up their remote classrooms in advance. If you're interested in having a remote classroom, shoot me an email or give me a call here at TAR and I will tell you how to do that. If you have technical issues with Zoom, I'm going to give you the number for that. It is 888-799-9666, extension 2. Please don't call up here to TAR with technical questions. We can't fix it. So you'll have to call Zoom, sorry. Everyone who's watching the webinar is going to be muted while it's going on. If you have board office that's participating for credit, you can raise your hand or just type in a question in the question box at the bottom of your screen. If you mouse over your screen, you'll see a little Q&A box. And we will keep track of those questions and get to them after Mishka is done with her presentation. We are recording this webinar, and a link to the recording and the slides will be available on the TAR website. You'll be able to find them on the events tool under events on the TAR website. If you look back to webinars, we will post those links there. Presenter today is Mishka Guillory of the Guillory Group in Houston. Many of you may have taken classes with Mishka before. She's a very experienced instructor who teaches a lot for us here at TAR, and she has her own program in Houston. And since we're talking about commercial forms, I also have with us David Jones. He's one of our attorneys here. Our good friend Kinski Moss, who's been our commercial attorney for a while, has recently taken on the role of Director of Board Services here at TAR. So David is going to be our commercial focused attorney moving forward. So welcome, sir.
Thank you, and good morning.
All right, so I've got Colin's question right here. Let's see. Please repeat the Zoom phone number. The Zoom phone number is 888-799-9666, extension 2 is that one. All right. That's all I know for now. Mishka, take it away.
The time. Good morning, everybody. I know you can't say good morning back, so let's go ahead and get straight to it. And David, by the way, nice to meet you. So let's get straight to the video or the slide presentation this morning. And bam, there we go. So again, you're taking how not to accidentally practice law using TAR commercial forms. And again, 1 hour of CE credit for those of you who are at appropriate locations. Let me minimize these windows here. So here are the objectives for the course today and a couple of introductions about the course. So this is what we're going to cover today, and hopefully it really truly covers all of your questions. We're going to be looking at available TAR commercial contracts and multi-use forms. We're going to, excuse me guys, we're going to define what actually is practicing law. We're going to discover when to change clauses in a TAR form and how to do it properly if it's necessary. We'll be defining what statements of fact are. We'll talk about if and when to get a lawyer involved, and we'll even talk about how, because there's a how component. And we'll be reviewing actual TAR commercial contracts. So we won't just talk about it, we're going to look at it as well. That's me right there. I think you can't see me on camera anymore, but that's my face. Like Amy said, thank you for such a great introduction. I've been in property management and landlord representation for almost 20 years now. Worked for some large companies like CB Richard Ellis, or CBRE. The JLL stands for Jones Lang LaSalle, and you can see the rest of the resume there. I do teach the Commercial Leasing 101 and Commercial Leasing Contracts courses through TAR. We've got one coming up in October, so a little plug there for TAR. And skipping down, those courses are also taught through HAR as well, for those of you who are in the market with me. And my experience with some past clients includes large names like Shipley's and Subway and Chick-fil-A. And I do miss Chick-fil-A because I miss my free coupons, but let's move on. I'll get a sandwich later. So here are a few house rules. Like Amy said, it's a 1 hour webinar. Logging out early will result in the loss of your CE credit if you're at one of those proctored locations. So hang tight. I promise to respect your time. And then hold questions if you can, at least for me, till the end of the presentation. But even if you type as you go, Amy will see it, and then we'll help them all or answer them at the end. And for those of you who may be at home, consider your camera. If you don't want us to see certain things, then you need to cover that sucker up. And if there's a question that I can't answer, that's what David's there for. He's going to help us out. And the last rule of the house is you guys got to have fun. I'm not going to sit here by myself and chit-chat and not have a great time if you're not having a great time. So let's hit it. First thing we're going to do is an overview of TAR commercial forms. There's 55 contracts that you all have at your disposal. 49 are just for commercial use, and about 6 of them are multi-use forms. Well, let's not talk about it. Let's look at it. So here is a list for you to consider. Let me hop over if I can. I'm going to see if I can do this successfully. Amy, I might need your help to get over to how you find all these forms on TAR. So let's look at them, and then we're going to practice hopping over. Almost every category that TAR has forms under, the 1300 category, the 14, 15, 18, 1700s, 2100s, and bopping over one page here, the 2200s and 2400s, almost every category has a commercial form in it, but it might not be that easy to locate. So what we've done is we've compiled this really quick list for you to be able to see what's available to you. These are the forms that we're going to talk about, and we want you to not practice law when using them, but we want you to use them. So highlighted in yellow are some of the more popular forms. Exclusive right to lease, you're going to find that under 1300, it's 1302. Please get comfortable with using the commercial buyer tenant representation agreement, that's 1502. There's your commercial LOI to purchase, and there is an LOI for leasing. Commercial contract special provisions addendum, we all kind of know what this is for. Special provisions is this teeny tiny paragraph that doesn't quite have enough room in it. So if you need more, guess what? There's an addendum for that. Down here, the biggest section perhaps is the leasing section. The actual lease document is 2101, and we'll visit that soon. And then one of the most important ones after your buyer-tenant rep agreement is your commission agreement, but it is called addendum for broker's fee. Just remember that's all about your money. 2102, don't forget it. And then some other forms, also under category 2100, you've got the commercial lease guarantee. And that is because in our industry, you're going to find that companies are not what landlords want to sign a lease. They want individuals responsible for fulfilling the lease if the company should fail. There's that commercial LOI for a lease. And then these final documents here in blue, these are the ones that are multi-use forms. They're actually under another category, 2200 for property management. And then, of course, there's others here in the 2400 category. I know that's a lot. So let me take you over to where to find these. And hopefully I'm doing this correctly. Let me get you over to the TAR website. If you're on the TAR website and you're clicking right here, for Realtor members, you're going to scroll down to where you see forms.
We can't see your computer screen, Mish.
You can't?
Nope.
Well,
minimize your slide.
Let me do that. Pulling it up and then minimize.
Okay. Here's what you need to do.
Dropping down. There we go. Are we there?
No. Click your shared screen, and you should be able to
resume share.
On your share screen, and you should click into the window that shows your desktop.
Awesome. So, we just don't look at that. I don't know.
Sorry. Okay, moving on.
Yeah, we'll move on, but you will go to the website and look under forms, and you should see a drop-down menu that will show all of those things to you. So we'll go back to the presentation and keep going. 1, 2, 3, 4, 5, 6 slides. Seriously now, let's get into what is practicing law. This is the heart and the meat and potatoes of why we're all here. We need to ask ourselves, are we doing any of these things? So let's talk about what TAR says first. TAR has in the Code of Ethics, Article 13, something that's really short, and it's got 2 simple directives. It reads like this: Realtors shall not engage in activities that constitute the unauthorized practice of law and shall recommend that legal counsel shall be obtained when the interest of any party to the transaction requires it. Again, there's just 2 parts. Realtors, you are not allowed to engage in UPL, which is the unauthorized practice of law, and you can't secure the advice of attorney for your client, but your client can get one. It's not going to be for you to secure the attorney. So you have to be cautious about how deeply involved you get with your client. TREC has rules too, though. Under Chapter 537 of the TREC rules, and you can find these on TREC's website as well, it's all there for you to see. Under Section 537.11, use of standard contracts, there's some real interesting language in there. When negotiating contracts that are buying the sale, exchange, option, lease, or rental of any interest in real property, a real estate license holder shall use only those contract forms approved for mandatory use by TREC for that type of transaction, but there's an exception. Transactions for which no mandatory TREC form exists. And guess what? That is a commercial form. TREC doesn't promulgate commercial forms. So what do we do if we're not allowed to use it? Well, check this out. If you continue through this part of TREC's rules, it says there's an exception. However, you can use a form that has been prepared by a lawyer licensed by this state or a trade association in consultation with one or more lawyers licensed by this state. That's going to be your association. That's TAR. So we love you guys for being there for us and having these forms. If you want to see these rules more closely, print them out for your office, here is the link. You'll have to, type it in by hand, but this is where this comes from. So we're not using TREC forms because they don't exist. We're using TAR forms, and we're using them with TREC's blessing. So there's more. Under that same section, it says that a license holder may not practice law. Number one, that's it, boom. But there's more. It says you can't directly or indirectly offer, give, or attempt to give, and this is the key word here, legal advice. Didn't say you couldn't give professional advice. You can't give legal advice. You also can't give advice or opinions as to the legal effect of any contracts, legal effect, or other such instruments that may affect the title to real estate. You can't give opinions concerning the status or validity of title. That's what the title companies are for. If you hadn't figured this out yet, this is kind of a reminder to stay in your lane. Now, the big one, the big one right here, the reason we even started this course in the first place is because so many people are petrified to do this. Draft language. License holder may not draft language defining or affecting the rights, obligations, or remedies of the principals, these are your clients, including escalation, appraisal, or contingency clauses. We're gonna see this come up again. You can't add factual statements or business details to a form approved by the commission, but remember, we're using TAR forms, but what it does say is this: if the commission has approved a form or addendum for mandatory use for that purpose. And what it is saying is this: doesn't mean that you can't add factual statements. It's saying if there's an addendum that will achieve that same goal, then you don't need to write things separately into the contracts. But we'll hit that one again. You cannot attempt to prevent or in any manner whatsoever discourage any principal to a real estate transaction from employing a lawyer. And here it is, plain as day, you can't employ or pay for the services of a lawyer directly or indirectly, so no sneaky stuff, to represent a principal to a real estate transaction in which the license holder is acting as an agent. So hopefully this is the beginning of solving the dilemma of practicing law, but there's a little bit more, so let's keep going. Did you know that in Chapter 537 of those TREC rules, Section 537.11, and David, correct me if I'm saying this wrong, is it subsection D or paragraph D? It includes this interesting clarifying point. It says, it is not the practice of law for a license holder to fill in the blanks in a contract authorized, a contract form authorized for use by this section. A license holder shall only add factual statements and business details or strike through text. And here is the most important thing you need to remember for the rest of your time as a realtor. As directed in writing by the principals. If they didn't write it and tell you to do it, you shouldn't do it. But you can if your client directs you to. So let's dig a little deeper and go down the rabbit hole a little bit more. So you need to start asking yourself some questions. You have to have an Urkel moment and go, oops, did I do that? Seriously, here's some of the things you might need to ask yourself Did I do these things because maybe you potentially violated Article 13 in the TREC rules we just reviewed? Does what you're saying or doing exceed the scope of your training? You're not trained to be a title company. Maybe some of you are, but most of you, I'm guessing, are not. Did you draft documents conferring legal rights or obligations? That's what the attorney is supposed to be handling. Did you prepare in writing or verbally express any legal opinion? Again, this is kind of a get out of this thing, don't do this. Did you represent parties in administrative or other proceedings and before any tribunal, or in parentheses, we're clarifying that's like a court. There is a caveat here, and hopefully David can clarify a little bit more towards the end. Non-lawyer representation is actually permissible in eviction suits for non-payment of rent or holding over. And you can look at 24.011 of the Texas Property Code for more details, and even the Texas Rules of Civil Procedure, paragraph 500.4. Also, did you negotiate legal rights or responsibilities on behalf of another? If none of you are attorneys, you shouldn't be doing this. It's okay to negotiate the terms of the contract, the length of the contract, the pricing that we're going to agree to, but legal rights is something you shouldn't be doing if you're not a licensed attorney. And then did you offer them advice or opinion regarding the resulting effects of contracts or actions or of the law? Again, advice and opinions are okay when it's in your wheelhouse, but when we get into legal advice, this is where we start slipping into trouble zones. So let's keep moving on. Everything you've heard, you can also find in an article online, and way down here at the bottom, you'll see the source from the Huffington Post in an article called The Unauthorized Practice of Law, a Cautionary Tale for Real Estate Agents. It was written by Nina Rise. She's a principal at the Rise Law Group, and she says the same thing, and she's even speaking to a national audience, not just a Texas audience. But she says courts have said agents and brokers can fill in the blanks in pre-printed agreements that have been approved by attorneys and our association, for example. And they have been just as clear in prohibiting us from interpreting the meaning or effects of provisions in those agreements. From drafting documents, if they exist elsewhere, we don't get to draft things, or attachments to the same, or from offering, and here it is again, guys, legal advice or guidance of any kind. So this means that regardless of his or her experience, and despite a client's expectations about how the client may benefit from your experience, an agent or broker is limited to just the facts, ma'am. So you have to get used to that. Amy, I'm saying Amy, excuse me, my friend Nina here goes on to say statutes, ethics rules, and courts have unanimously agreed that a real estate agent cannot give advice or offer an opinion on the legal effects of a contract. So again, even on a national level, she's speaking to a broad audience, but it still says the same thing. She's admitting, though, that in the real world, these questions do come up, and in at least some instances, the agent has actual experience dealing with potential fallout. But as difficult as this is going to be, and as tempting as it sounds to offer a client the benefit of all your years of experience, an agent can only point out the relevant provisions of a contract that apply without attempting to interpret them and advise the client to seek legal counsel. That's all they can do. Just advise them to seek the legal counsel. She says this is going to be frustrating, and it is, but if you find yourself doing it, just take a step back, breathe, and remember there's some repercussions for doing these things. So let's kind of check out one little paragraph that TAR put in place to help you if you're not even comfortable telling your client, I can't do certain things for you. This right here is Commercial Lease Form 2101. This is just a piece of it. But right before the signatures is this handy dandy reminder. And it says, brokers are not qualified to render, there it is again, legal advice, property inspections, surveys, engineering studies, etc. So the parties should seek experts to render such services. Read the lease carefully. If you don't understand something, and that's Mr. or Ms. Client, if you don't understand the effect of this lease, guess what it's telling your client? Go consult your attorney before signing. So again, if you're not so comfortable telling your client, hey, I can't really answer that for you, you can always point to this paragraph as kind of your out, so to speak. So what happens if you accidentally did it? You had a Britney Spears moment and you did it again. There's a couple of things that could happen. The unauthorized practice of law, that's what UPL is, it's both a TREC and TAR violation. And it's possible for a realtor to face discipline from both of these groups. Both groups operate from complaints, so someone would have to file a complaint of UPL against a realtor for TREC and TAR to get themselves involved. So let's look at TAR first, briefly. TAR only deals with complaints against members of the association. So if you're dealing with a colleague who is in commercial, but he's not a realtor member, you're going to have to jump over this and go on down to TREC to launch a complaint. But let's assume we're dealing with someone who's a member. It says that TAR has no authority over non-members. So sanctions can be monetary fines, mandatory attendance at CE courses, and they can suspend or revoke your membership in your association. They cannot, however, at TAR, suspend or revoke your real estate license. That's not TAR's role. So ethics complaints. TAR handles enforcement of the NAR Code of Ethics. There's even an ombudsman service as well as mediation that's available before an official complaint is filed. And I've just got to ask the question, how often do you get to say ombudsman in life? It's pretty cool I get to say that today. And the Texas Real Estate License Act and TREC rules violations, TAR has no authority to enforce them. So we're going to hop down to the group that does get to enforce that. Again, that's TREC, your Real Estate Commission. They deal with complaints against everyone, all license holders, not just realtors. So you all could potentially have a double whammy for goofing up if someone reports you. TREC complaints are handled by the Standards and Enforcement Services Division. Sanctions can be monetary fines, suspensions, or revocation of your license. You need to be cautious about not practicing law. For the Real Estate Licensing Act and TREC rules, it says for violation of these things, file a complaint directly with TREC, and they do have mediation procedures. So let's continue along the path of not getting a complaint filed against you. So wait, can you do that? Let's find out what you might have been doing and are you able to do it? Here's a quick at-a-glance chart of some examples of what you can and can't do. Interestingly enough, there's nothing towards the center. Deleting paragraphs, yes, you can do it. Striking through, you can do that. Writing in the margins, yeah, kind of depends. Adding new paragraphs, it depends. Adding more special provisions, yes, you can do that. And changing contract terms, well, again, it depends. But let's get on into how you do these things. Can you really do all that? What is the catch? Well, sure you can, but here it is, right here. All of these changes may only come at the direction of your client, and they must be put in writing. We saw that earlier in the rules. It has to be put in writing, and they're the ones that need to direct you to do so. So let's take a little look at how that may come off with a TAR contract. Again, we're looking now at the expense reimbursement addendum. It's Form 2103 as indicated down here at the bottom. Form 2103 has a paragraph that we use quite a bit in commercial leasing, and it's the reconciliation paragraph. Shameless plug, if you want to know more about what that's for, join us in October for the boot camp that goes over commercial leasing contracts. Okay, back to class. This particular form says that the tenant's got to pay a deficient amount to the landlord within 30 days after the landlord tells the tenant, hey, you're a little short here, you owe me some more money. You might have a statement of fact added into this lease under special provisions. And statements of fact are okay. An example of what your principal may tell you to write might say the landlord will grant the tenant another 150 days to pay any deficient amounts referenced in paragraph D. This is fine. It can be inserted in there. But don't forget the things we discussed, and here's a quick summary. You can add these things in there, but it must come, again, what's the catch? Your client needs to instruct you in writing to say this, and the language must be drafted by your client, not by you. So none of you go borrowing the language I wrote on this slide. It is not for you to cut and paste and use. It's just an example. But again, this is the catch. Again, per TREC Rule 537.11, it needs to come from your client in writing, and you cannot draft the language. I would even go so far to say, if there's a typo in the language, tell your client, have them correct the typo. But if they give it to you a certain way, then that's the way it should go into the contract. So let's look again. This one is the commercial lease document. It's formed down here at the bottom, 2101. And we're going to look at the relocation paragraph, one of my faves to teach when we do the boot camp course. And this paragraph gives the landlord the power to move a tenant from the current space they're in to another space on the same property. This paragraph also gives the tenant the power to say, I don't want to be moved. But what if you agree to relocation and you click this box? I like the paragraph the way it is written, but your client may want this paragraph expanded. What this paragraph says is, if I have to be moved, you're going to pay for lots of things for me. You're going to pay for the movers. You're going to pay to put the suite back the way I had it built. But there's this little thing right here that TAR was creative enough to put into the document that says, Mr. Landlord, you're also going to reprint my stationery and business cards because, in effect, when you moved me, my address changed. And that is a very legitimate, very helpful clause. But in my experience, some tenants want a little bit more. They want to make sure that anything that has an address printed on it also gets recreated or paid or reimbursed. That might be a t-shirt, marketing brochures, etc. So you may add as a statement in fact, back in that paragraph 35, special provisions, at the direction of your client, something that may say the landlord will also pay for the printing and or reproduction of any marketing materials that include the current tenant address. Mind you, this should come from your client in the language they draft, but that's another occasion where you're going to want to alter something, or your client wants you to alter something, and how you can achieve it. Striking through documents. It can actually happen. We don't see it often because we are all petrified of doing this. But if it doesn't apply, for example, the after hours HVAC charges paragraph, and that's the heating, ventilation, and air conditioning paragraph, mostly applies to office buildings because retail tenants handle their own HVAC. I had a client myself who was in a retail setting that just didn't want this paragraph in the document. So at his direction in writing, we struck through that paragraph because it just doesn't apply. It just doesn't work for retail. And again, this is part of the commercial lease document down here again, Form 2101. And again, that paragraph just doesn't apply. So my client did ask me to strike through, and I do prefer, and this is a personal preference, to leave the language visible so that we can remember what we struck through rather than blacking everything out. Continuing forward, this is, you're going to need to remember this is your broker's fee. This is your money. This is how you get paid. So this is Form 2102, bookmark it, make a note. But the form states in paragraph A to C, and again, here it is, A to C, it states nothing. But in our business, chances are this will be the option you're going to select when it comes to getting paid your commission. The question becomes, how do I fill it in? Here is an example for you of how you might fill it in. You might say, I want 4% of the base monthly rents, et cetera, and you may say payable as follows. I want half at the time we execute and half after the lease commences, and that's fine. But some of you will be concerned about, wait a minute, I thought I wasn't supposed to insert statements of fact in the lease. What TREC rules say is this: if there's a form for that, then you can't insert it. But there is no form giving you a choice of how you get paid. There's no menu of selections for I get paid immediately upon commencement, or I get paid 6 months after the tenant moves in. There's no menu of choices. So you need to fill in what it is you want in terms of how you get paid. So it's okay. What about writing in the margins? Can I do that? Now, I love David and Amy and Kinski Moss and everyone who helped with the writing of this course. And while there is no hard and fast rule that says, no, you can't, it was the consensus that perhaps you shouldn't, which is why the big no is over here on the right side of the screen. Writing in the margins begins this process where everyone suddenly wants to initial, and you'll potentially have 4 people initialing every single change in the margin. Those 4 people would be you, the other realtor, the tenant, and the landlord. It would get very messy. At the direction of your client, use special provisions. Don't forget, when we looked at the list of forms, there is a special provisions addendum, because as you can see, there's not a lot of room here, particularly on the lease guarantee form. So writing in the margins, I am saying no, but the consensus was it just wasn't the best idea. It gets messy. Maybe you should just stick to using the special provisions. So the takeaway here is, remember, all of these changes may only come at the direction of your client and after they put everything completely in writing. If it is written and it is confusing to you, then you may want to advise your client to have that language reviewed by an attorney, but you cannot advise them on what it is you think you read or what you're seeing. But we're not done yet. When is it time to get some help? And even better yet, how do you get help? There's some rules here too. So calling for help. Here's some signs that you actually might need to have your client secure an attorney, or you might need to secure one yourself. If your client asks you to interpret any clause in a contract, again, that gets you into that legal interpretation, have them call an attorney. If your client asks for your opinion about, again, the legal aspect of a transaction, how this may wash out in a court of law, for example, that's going to be an attorney. Have them call someone that can answer this question proficiently. If your client asks you to draft new language, draft a new paragraph or even a whole new clause for the contract that is not a statement of fact, that's not what we do. We're not in the drafting business, of course, unless you have dual licenses and you happen to be a lawyer as well. If your clients ask you about your other clients' experiences with a similar transaction or predicament, the reason this is on the list is because when you start sharing, you may be violating privacy regulations anyway. So it's not the best idea to share what happened in someone else's transaction. But by sharing that information, they may assume that is your advice. So be careful of the slippery slope, because you may be violating a couple of regulations, which may get you in front of that tribunal we saw earlier, and we don't want that. If your client asks you to use their contract and not a TAR contract, if you're not comfortable with it, they're going to need to bring an attorney in. There are lots of clauses in there you weren't involved in creating, and TAR's lawyers weren't involved in creating. That's lawyer time. And if your client asks, well, what would you do? If you don't know that that is a signal, a red light, I gotta tell you, you need to back up a little bit. Anytime someone says, well, what would you do? This is that moment when you don't let 20 years of experience and a little bit of ego answer the question. Now that you've been informed, be cautious, because you may slip into the unauthorized practice of law by accident. And as we round the bases on finishing up this presentation, who are you going to call, guys? This is our Ghostbusters moment. And let me apologize for my Britney Spears references and my Urkel references. I just got to keep myself entertained on this side of the screen. But really, who will you call? So For all of my colleagues out there, there is the TAR legal hotline. I love this thing, but I've got to give you the warning if you've never used it before. For brokers, if you've never had one of your agents call, please know that if an agent under you calls the hotline, you're going to get an email notifying you that your agent called. And agents, if you forgot to tell your broker that you're calling, they're going to get an email. For any of you who hadn't seen that before, like my very first time, I flipped my wig when my agent called and I got that email. Scared me to death. And then I found out he just needed help on which form he uses for a certain transaction. But they're there to help you. They cannot give you the full scope of legal advice, but the best bet is to call first, ask your question, and see where they advise you to go next. You might get the answer you need, and then they might tell you to secure an attorney, or they may tell you to tell your client to secure an attorney. And if your client does say, well, do you have any attorneys you'd recommend? I am not a proponent of recommending. Once you recommend, that's almost like advising. You don't know any attorneys. I don't care if your mother's an attorney. You don't know her. So here's what you can do. Reference or refer them to the Texas Bar, the State Bar of Texas. And here's the website, texasbar.com. They can use the Find a Lawyer feature. This way, you don't accidentally give them a list of recommended attorneys. Something goes wrong with that attorney, you may find yourself caught up in a situation of, well, you're the one who told me to use that attorney. So again, your best bet is to kind of back out as much as you can. If your client needs counsel, have them secure their own attorney. So with all that said, it is now time for your questions and answers, coming from hopefully David or myself. Stopping the share. Everyone's face should be back up.
Unmuting. Okay, I see that people have raised their hands. So what you guys need to do is type your questions into the question and answer box so that we can read them. Amy, I'm unable to unmute you for some reason. And
I kept on saying no.
Okay, there you are. Did you have a question?
I do.
Speak up, dear. You're kind of quiet.
Okay. Can you hear me?
Yes.
Okay. It's related to what you were talking about, these initial conversations with our customers. Are things on social media, and particularly I know on Facebook you can have links to all of the details, but we're exploring Instagram, and I don't know how we can have what is the rules around the around having these initial conversations on Instagram.
You mean a conversation with your client?
It's not with our client, but is a post ruled as that's an initial conversation, I guess?
Okay, David, I'm leaning on you for this one because my vote is not to post certain things on social media. Social media is the biggest trick bag, and I do believe personally that it's still completely uncharted waters. But David, what is the hard and fast rule on this one?
Well, I'm having a hard time understanding how that would lead into the unauthorized practice of law. I mean, if you're giving legal advice wherever you're giving it, it's still going to be unauthorized practice of law.
Did you guys hear him?
A little bit. Can you get a little closer to the mic?
Sure, how's this?
That's even better. Great. Can you repeat it though?
Sure, I was just having a little trouble understanding how that related to unauthorized practice of law. Could you maybe explain the question a little bit? Like, what are you saying on social media?
We wouldn't, this is actually what we're trying to figure out. We wouldn't be saying anything that is, at least in my opinion, that would be practicing law or providing information, but it's just providing information out there, but it's that initial conversation that has to have all kinds of potential disclosures. And that was where I was asking it. But I don't.
Oh, I see. So like the disclosure notice that you have to put in your emails and things like that, How do you do that on social media? Those are advertising questions, are they not?
Yeah, that's getting more into advertising as opposed to accidentally committing unauthorized practice of law.
Yeah.
Okay,
I
thank you.
think maybe a hotline call might be in your future.
Okay, I'll do that.
All right, we have a couple more questions here. Avery asks, can an agent act as a trustee for a client who is interested in buying a property? David?
I don't know if that's an unauthorized practice of law situation.
Yeah, I would agree.
All right, I have a sales licensed agent saying to me that it's okay to advertise as a commercial broker in the commercial space, even if you don't have a broker's license. Is this correct? There is no such thing as a broker's license or a commercial
License, right.
and if you're not a broker, you should not hold yourself out as a broker under any circumstances. Although I'm not an attorney, that just seems like common sense to me.
Yeah, again, that's another advertising questions, and that would be.
Okay. Someone asked, does your client need to put in writing to you what they want you to strike out?
Yes, absolutely. No manipulating the contracts unless it was directed by your client.
I would also add, it could also come from your client's attorney.
Good point.
All right. In drafting a new paragraph, joint effort, I think that means between the client and the agent, is it considered practicing law if you, the broker, have part ownership in the transaction? Ooh.
Good question.
Good question.
If you are part owner and you are actually a party to the contract, you have more freedom there. Unauthorized practice of law is when you either give legal advice or if you draft legal documents for somebody else. Okay, so if you are a party to the transaction, and I'm assuming you would be as part owner, if you're a party, if you're signing in the buyer or tenant or landlord signature and not just a broker, if you're actually a party, you would be able to make these changes. You are not subject to the unauthorized practice law. Parties to the contract can change and write their own contracts.
That's why it requires you to get that request from your client in writing because they are a party to the client, to the contract. All right. Okay. Surely that can't be all the questions people have about unauthorized practice. Oh, here we go. Okay.
I see a hand.
Yep. All right. We got a couple more.
Based on
Client
what
provides his own contract. Why do I have to get legal advice if it came from the client in writing?
I didn't even hear half the question, Amy. Can you repeat it?
Sure. If a client provides his own contract, why do I have to get legal advice if it actually came from the client in writing? So the contract, I'm assuming, is the writing.
Well, you're not giving legal advice at all. Even if it came from the client, manipulating contracts is something we can't do. Altering contracts is something we can't do. It would still have to come at the direction of your client to do something, and if it's their contract, then they'll need to have their attorney take care of that.
Okay. Someone asks, can a commercial broker use a non-TAR tenant buyer agreement without having the attorney's info that drafted the tenant buyer rep agreement or engagement agreement? I have heard that if you are using an attorney's drafted document, the name of the attorney should be listed. Is this correct?
Yeah, this is David. That's going to go to TREC Rule 537.11. I wouldn't give you specific advice on that situation, but if you're going to use a non-TREC or a non-TAR form, if you're getting a form from an attorney, take a close look at TREC Rule 537.11 and just make sure whatever form you're using is going to be in compliance with that TREC rule.
That does mean created by a Texas attorney. So if their attorney is coming from out of town, David, I'd like to ask you, are we allowed to be a party to that? If it's from, I don't know, their attorney is in Arizona.
Yeah, it could be, because some, you have international deals, you have deals from a buyer from out of state might be purchasing Texas property, and they might come with a contract from their attorney in whatever state they're in. So it's still a possibility that you can use a contract. It all just has to comply with 537.11.
All right. Someone asks us if a leasing company strikes through statute. If a leasing company strikes through, I think that might be the contract. Can we require them to produce the letter from their client, give to our client prior to signing? So I think that question is making sure that the direction came from the client as opposed to from the leasing company that is representing the client.
Oh, I got it. It took me a minute to catch who was who in this transaction. And so basically, this is a third-party representative of the client, and they've been secured to represent the client. David, I don't see any reason why you cannot move forward at that company's advisement if they've been secured to represent the landlord.
Yeah, I mean, that's fine. If you are the broker representing the tenant, I'm assuming, and then you get a lease from the leasing company and it's got all sorts of alterations, it's not necessarily your duty to go and to figure out to make sure that the leasing company did things correctly. You can, if you feel that that's what's in the best interest of your client. Just remember where your fiduciary duty lies. It's to your own client. You're not necessarily have to protect the leasing company and make sure that they're okay. If they did something that they shouldn't have, they're the ones who are going to face discipline. You have to look out for your own client, which would be the tenant in this situation.
All right. Is there a way to get copies of the slides? Yes, we will be posting them in the events tool on the TAR website. Someone says, can you explain what a paragraph means to your client if it's in regards to a question to a listing agreement and not contracts?
Well, the listing agreement, brokers, you would be a party to that contract. However, you still want to be careful of crossing the line into giving legal advice. You can alter a listing agreement. You can add special provisions in there because you're a party to it. But you still would not be able to give legal advice to your client.
Okay. Yeah, I mean, I don't practice real estate, this is Amy, but when it says you cannot interpret any clause, that does sound kind of scary, because I'm sure many agents and brokers are faced with a client who says, I don't understand what that means. What are they asking me here? How does a person handle that situation, Mishka?
Personally, when that happens for me, I will tell a client this paragraph addresses the following. If you needed to say more, however, you need to call your attorney for them to either tell you it is written in your favor or it is not written in your favor. The easy example is the HVAC, after hours HVAC paragraph that's in the lease document 2101. If you are in an office building and you do need to run the air conditioning or heater after hours, what is that for? Well, I can tell you that paragraph just charges you for running the air conditioning after the landlord would normally stop the air conditioning in an office building. But then when it comes to advising you how much you should pay for that, what else does this paragraph say? I don't get into that. I actually do refer to an attorney. I can only tell you what the paragraph's for.
Okay. Someone asked, if a contingency is added to the contract, is it enforceable if written by the client or agent?
Agent shouldn't be writing it at all, and that should scare you to death. You write a contingency, that means that new paragraph is impacting several other paragraphs. And without being an attorney, you may not understand the chain of events that you're affecting by adding this contingency. So per the rules that we've covered today, definitely have your client call an attorney to do that kind of a paragraph.
Okay, I would also add, if a broker or agent writes something into the contract that they should not have written, it is a clear unauthorized practice of law. If it's in the contract and the parties sign it and execute it, it could very well still be enforceable on those parties. If they saw it and read it and signed it, they agreed to it. That is kind of one of the dangers, is that if a non-lawyer wrote this provision in there, now it's going to be binding on their clients. Okay, and if something goes wrong and your client loses a boatload of money, who do you think they're going to come after? They're going to come after whatever agent wrote it that shouldn't have wrote it.
All right, so we have a clarification on an earlier question here. If a client provides his own contract, assuming it was drafted by an attorney, can I use it in their transaction, or should I just say I can't deal with this contract, have your attorney negotiate everything, and have you and the other party sign it? Okay, I think that's a little clearer then.
Okay, I'll answer that one. Again, this is about TREC Rule 537.11, which states that if you're negotiating a transaction, you have to use a TREC form, and then there are 4 exceptions. Okay, one of those exceptions is what allows TAR to provide you forms for you to use. Another exception is if you're solely a principal, so if it is your own property that you're buying or selling, you are not limited to just TREC contracts. A third exception to having to use TREC contracts states, and I'll read it verbatim. It says transactions for which a contract form or addendum to a contract form has been prepared by a property owner or prepared by a lawyer and required by a property owner. So that is one of the exceptions that would allow you to still be able to negotiate that deal. If there is a contract that came from the property owner or prepared by a lawyer and required by a property owner.
That makes sense.
Okay.
All right.
It does.
I have a question. So, if you happen to be an agent or a broker who is also an inspector or perhaps does have engineering training, because that's an exception, if you're performing a transaction for a client and say there's an engineering question, are you allowed as an agent to, quick like a bunny, take off your realtor hat, put on your engineer hat, answer the question, then put your realtor hat back on? Can you do that in a transaction?
Personally, I'm thinking you can, but I would venture to say, and David, help me out on this one, if you're going to be the named attorney, I would think somewhere it needs to be written that you're not just throwing advice out there because you have the license, that you are the named attorney or appraiser or inspector to the transaction. You've actually been hired and secured to be that person.
Yeah, if you actually do have expertise or a license in some other field, you're not prevented from answering those questions. That would be within the scope of your knowledge. But just remember that you're now bringing in additional liability for your answers. So if you are an engineer and you start answering engineering questions, well, if you get something wrong, now your client can come at you for that. So if you've got multiple hats, it's up to you to decide which hat you're going to be wearing.
Okay. Someone asks, can I sell a property in another state for a Texas resident?
You would have to check the laws of the state that the property is in. If the property is in Texas, you have to have a Texas real estate license. I'm assuming, I don't know all 50 states, but I'm assuming they probably have a similar rule.
Okay. Most of the clients I work with are foreign national companies from Canada and Europe, and they like to use their own company attorney to sometimes draft or change the language of the contract. Do these companies need to contract a local licensed Texas attorney, or is it okay for them to use their corporate attorney?
Again, that would fall under the same exception under 537.11, that if a a contract comes from the property owner or prepared by a lawyer and required by a property owner, it could potentially fall under that exception that would allow you to still negotiate that transaction.
Someone is clarifying to sell the other property in another state using TAR documents, but I think it still falls under the same caveat of checking the other state's licensing requirements, right?
That's correct.
Mhm.
All right. By requesting proof that the owner did in fact direct the other broker to make those changes, am I practicing law? Ooh, that's interesting.
I missed the first part of that. Can you repeat it again?
By requesting proof that the owner did in fact direct the other broker to make those changes, am I practicing law? So if someone says, I'm not sure that your client actually wants you to do that, can you show me where they directed you to do that? Are you then practicing law?
I don't think so. I think you're covering your behind, but that's just me. As a matter of fact, I should have said, because this is part of what I do, when I am directed by my principal to put something in a contract via email, which is how I like to get it, I print out the emails and attach it to the document, put it in my file so that I've got proof that I got direction to do what we did.
Okay. All right, someone asks, since I cannot come up with the wording, can I as a realtor have a lawyer write proper wording to put into a contract, or does my client have to hire the lawyer?
Yes, your client. You're not allowed to secure the attorney.
Right, so
Secure their own.
you get your attorney if you need the attorney. Your client gets the attorney if your client needs the attorney, right?
There you go. No recommending, no suggesting. They get theirs, you get yours.
Okay, all right. We have last call for questions.
Oh.
We've gone over time a little. No? All right. It looks like that's going to close us out. All right. I am going to close us out with a few comments. Tell you guys again where you can find this when it will be posted on the website. Michigan, thank you so much. This was great, and I think
Thank you.
out of this. We will post this webinar again on the events tool on the TAR website. You can go there and check it out. Look under past webinars. It'll probably be there by the end of this week. It takes us a little while to get everything together. Our next webinar is on September 18. This presentation will be an update on all the new RPR commercial features and how to use them to make your most compelling presentations. We do have this webinar approved for CE if you view it at a proctored location. If you're interested, contact your local board to see if they can host that. We always give the local boards first right of refusal to host our webinars, but if they don't, do it, get hold of me or Don Hauser in professional development, and we will set you up with a remote classroom. We will be sending out an email with the details on the class, and I'll be posting it on our Facebook group, which reminds me that we have a Facebook group, and you can find us there. It's TAR Commercial. We're also in the early stages of creating a statewide calendar of commercial events and education on our Facebook group. So if you have an event or a class you'd like to put there, you can look in the announcements on the Facebook group, and we have uploaded the form to submit to me that tells us all about your event, and I will type that in and put it. If you can't find that, again, just call me here at TAR or shoot me an email. It's agamber, AGAMBER. It's like gambler, but with no L, at TexasRealtors.com, and I will send that to you. And we're working hard to create one place where everybody can go to find out all of the commercial activities that are happening around the state. So please don't be shy about submitting us your classes and events. We really want to get all that information out there for you. Online registration is still open for the Realtors Conference. I believe it closes tomorrow though. So if you don't get registered online tomorrow, you will have to register on site. It is in San Antonio, which is always a good time. from September 7th through 11th, and the commercial events are going to be on the first 2 days, the 7th and 8th. We're really excited about our schedule. We hope that a lot of you can come visit us there. The bus tour this year is going to be of the new Brooks development, which is a new multi-purpose Brooks Air Force Base, which is really exciting and filled with a lot of amazing history as well as so we hope we can see everybody. I believe that's it. I know that we have a couple of other unanswered questions, so I'm going to find somebody to answer these, although Anonymous may want to fill in their email for me, and we'll try and get those answers to you. Thanks for looking at it now.
Look at y'all. Yeah. Where we are.
Very well somewhere. And that is it.
Thank you very much.
Guys, have a great day. Thanks for joining us, and we'll see you soon. Bye-bye.
Bye.